They will tell you the law was on their side. They will tell you that a white man leaving his estate to an enslaved woman was an aberration, an error of judgment made by a man in declining health who was not fully in possession of his faculties when he signed the documents. They will tell you that the subsequent 12 years of litigation were not an attempt to steal what had been given, but a necessary correction of an impossible situation, a restoration of the natural order that one confused old man had briefly and regrettably disrupted. Let them tell it that way. I have listened to that version for 12 years, and I have never once found it convincing. My name is Celestine. I am 47 years old. I was born enslaved on the Marchand plantation outside Baton Rouge, Louisiana, in the year 1809, the daughter of a seamstress named Violette and a carpenter named Henri, who built half the fine furniture in the plantation house and was never once asked to sit in any of it. I was the property of the Marchand family for the first 22 years of my life, and then I was the property of a man named Augustin Renard for the next 16 years. And then, on a Tuesday morning in October of 1847, I became something that Louisiana law had considerable difficulty categorizing. I became a widow, not a legal widow. The law of Louisiana did not recognize the marriage between Augustin Renard and me as a marriage, because the law of Louisiana did not recognize marriages between white men and enslaved women, because the law of Louisiana did not recognize enslaved women as the kind of people who could enter into marriages. What the law recognized was a property transaction, the transfer of an enslaved woman named Celestine from the Marchand estate to the household of Augustin Renard in 1831. And what the law had considerable difficulty processing was the document that Augustin Renard had signed in the presence of 2 witnesses and a notary in September of 1847, 6 weeks before his death, which freed me, freed our 3 children, and left me the majority of his estate. The document was legal. His lawyer had drawn it up. The notary had witnessed it. The witnesses had signed it. Augustine had been examined by his physician the same morning he signed it and declared to be of sound mind and competent judgment. Every procedural requirement had been met with the deliberate precision of a man who understood that what he was doing would be contested and had taken every available step to make the contesting as difficult as possible. It was contested anyway. The Renard family, led by Augustin's younger brother Philippe, and supported by 3 cousins and the considerable weight of Baton Rouge social opinion, spent 12 years attempting to overturn what Augustin had done. 12 years of litigation, social pressure, legal maneuver, and the kind of sustained institutional hostility that a free black woman attempting to hold property in Louisiana in the 1840s and 1850s faced as a matter of ordinary daily experience. I held on for 12 years, not alone, but I held on. This is the story of how. I will not tell you that Augustin Renard was a good man in any simple sense, because simple senses are not adequate to the complexity of what he was. He was a man of his time and his place, which meant he was a man who had been raised to believe that the ownership of people was a natural and unremarkable feature of the world, that the hierarchy of race was divinely ordained, that his comfort and prosperity were built on a foundation of other people's labor and suffering in ways that he had learned not to see clearly. He had purchased me at 22 from the Marchand estate when I was a domestic servant of established skill and reputation, paying $800 for me at a private sale that was arranged through a business connection of his father's. I was a purchase, an asset, a transaction recorded in his ledgers alongside the purchase of a new carriage and 3 bolts of imported silk. What happened after that is not simple to describe, and I will not try to make it simple. I will say that Augustin Renard was a man who was capable of genuine affection and genuine respect across the boundary of race and ownership that his world insisted was absolute, and that over 16 years the relationship between us became something that neither of us had words for in the vocabulary available to us. Not slavery, though legally it remained that. Not marriage, though it functioned as that in most practical senses. Something that occupied the impossible space between those 2 things, sustained by the particular kind of intimacy that develops between people who share a life completely and honestly over a long period of time. He was 38 when he purchased me. He had never married. He had the means and the social position to have made a conventional marriage years earlier. But he had not, for reasons he explained to me once, late in our years together, with the careful honesty of a man accounting for his own history. He said he had never found a woman whose company he preferred to solitude. He said this without any awareness of the irony, because the woman in whose company he had spent 16 years was sitting across the room from him when he said it, and he had simply forgotten, in the way that people forget the obvious, that I was a woman. He remembered when I pointed it out. He was quiet for a moment, and then he laughed, and then he was serious again, and he said, "I know, and I don't know what that means about me, or what it costs you, or whether what I feel for you is adequate to what I owe you. But I know that you are the only person in my life whose presence I have never found anything but necessary." That was the closest he came to an apology, and the closest he came to a declaration, and I accepted it for what it was, which was honest, which was more than most people managed. He was 54 when he died. His health had been declining for 2 years, a heart complaint that his doctor had managed with limited success, and that had finally resolved in the manner all such complaints eventually resolve. He died in his bed on a Tuesday morning in October of 1847, with my hand in his and our 3 children in the room, and with the legal documents that would define the next 12 years of my life, already filed with the notary's office in Baton Rouge. He had told me what was in them 6 weeks earlier, when he signed them. I had listened and felt the weight of what he was giving me, and felt simultaneously the weight of what it would cost. I knew Philippe Renard. I knew Baton Rouge. I knew Louisiana law and Louisiana society, and the specific hostility that both reserved for free black women who attempted to hold property in the state. Augustin knew it too. He said, "I know what this will bring. I know it will not be simple. I know Philippe will fight it, and the courts may not be fair, and society will not be kind. But I cannot leave you with nothing. I cannot die and leave you and the children with nothing." I told him I understood. I told him I would manage it. I told him this with the confidence of a woman who had spent 16 years managing things that should not have been manageable, and who had developed in the doing of it a set of capabilities that would be tested more severely in the 12 years after his death than in everything that had come before. I was right that I would manage it. I was not right about how hard it would be. The document that Augustin had signed was comprehensive. His lawyer, a man named Fontenot, who had been Augustin's legal advisor for 20 years and who had prepared the document with visible discomfort but genuine professional care, had constructed it to address every foreseeable challenge. It freed me first. A formal act of manumission, legally precise, filed with the appropriate authorities, converting me from property to person in the single stroke of a pen that Louisiana law permitted a white man to make unilaterally. This was the foundation on which everything else rested, because a person who was still legally enslaved could hold no property and contest no claim. I had to be free before I could be anything else. It freed our 3 children, Josephine, who was 15 and who had her father's methodical mind and her mother's instinct for what was happening beneath the surface of visible events; Thomas, who was 12 and who was his grandfather Henry's grandson in every way that mattered, with the carpenter's eye for how things were built and how they could be rebuilt when they broke; and Marie, who was 9 and who was simply herself in a way that I had never seen in any other person, fully and completely herself from the moment of her birth, impossible to contain in any description that didn't acknowledge the specific force of her particular personality. 3 children freed, 3 lives converted from property to person in a document that Philippe Renard's lawyers would spend 12 years attempting to characterize as the product of an unsound mind. The estate itself was divided. 1/3 went to the Renard family, specifically to Philippe, which Augustin had included as a calculated concession designed to reduce the financial motivation for an all-or-nothing legal battle. 2/3 came to me, in the form of the house in Baton Rouge where we had lived for 16 years. The income from a commercial property on the main street that generated approximately $2,000 per year in rental income, a sum of $12,000 in the Citizens Bank of Louisiana, and the furniture and household goods accumulated over 2 decades of prosperous domestic life. The total value of what Augustin left me was considerable. Not enormous by the standards of Louisiana's wealthiest planter families, but substantial enough to represent genuine financial independence if I could hold it. Substantial enough, in other words, to be worth fighting for from both sides of the conflict it immediately produced. Philippe Renard filed his first legal challenge within 3 weeks of Augustin's burial. Chapter 3. Philippe. Philippe Renard was 50 years old when his brother died, 3 years younger than Augustin, and as different from him as two men raised in the same household by the same parents could be. Where Augustin had been reserved and precise and somewhat indifferent to social opinion, Philippe was expansive and socially active and deeply invested in the Renard family's standing in Baton Rouge society, which he understood to depend on the maintenance of the kind of respectability that his brother's arrangements had, in his view, catastrophically compromised. He was not purely mercenary. I want to be accurate about this because accuracy serves me better than the simple narrative in which Philippe is simply a villain motivated entirely by greed. He was motivated partly by greed. 2/3 of his brother's estate was a significant amount of money and property that he believed should have come to the family. But he was also motivated by genuine social anxiety, the fear that the Renard name had been attached to something that Baton Rouge society considered scandalous, and that the scandal would continue as long as I was visibly holding property under that name and living in the house that his brother had shared with me. He had 3 legal arguments, and he deployed them in sequence over the 12 years of litigation, each one designed to accomplish the same goal through a different mechanism. The first argument was that Augustin had not been of sound mind when he signed the documents. This was the argument Philippe led with, and it was the one that had the least factual support and the most emotional resonance with the judges and juries who would hear it. A white man giving his estate to an enslaved woman was, in the social context of Baton Rouge in 1847, so anomalous that the anomaly itself was treated as evidence of impairment. Never mind the physician's certification, never mind the testimony of Fontenot, who had known Augustin for 20 years and who testified that his client's mind was entirely sound at the signing. Never mind the careful legal construction of the document itself, which bore every mark of deliberate and competent intention. The argument was that the act itself proved the impairment, and in Louisiana, in 1847, that circularity had considerable purchase. The second argument, deployed after the first failed, was that the manumission was procedurally defective. Louisiana law required specific procedures for the freeing of enslaved people, procedures that Fontenot had followed carefully and that Philippe's lawyers spent 3 years attempting to find defects in. They found no defects of substance, but they found several procedural ambiguities that they exploited with the creativity of lawyers being paid to find something that wasn't there. The third argument, which emerged in the later years of the litigation as the first 2 were progressively exhausted, was that even if the manumission was valid, and even if the bequest was valid, I lacked the legal capacity as a free woman of color in Louisiana to hold the specific forms of property involved. Louisiana's laws regarding the property rights of free people of color were complicated and shifting, and Philippe's lawyers proved adept at finding the complications and shifting them in directions that served their client. 12 years of this, 12 years of arguments and counter-arguments, of court dates and continuances, of legal fees that consumed a portion of the estate I was fighting to protect, of a social environment in Baton Rouge that was almost uniformly hostile to my position, and that expressed its hostility in ways ranging from the formal to the personal. I held on through all of it with 3 resources that Philippe had not fully calculated when he decided to fight me. The first was money. Augustin had left me enough that even with the legal costs I could sustain a prolonged defense without becoming financially desperate. The second was Fontenot, whose professional pride in the document he had constructed was sufficient motivation for him to defend it with a tenacity that went somewhat beyond what his fee alone would have produced. And the third was something Philippe had no framework for understanding at all. I was very good at this. 16 years of managing Augustin Renard's household had given me an education that no institution would have recognized, but that was more practically comprehensive than most formal educations produced. I had managed a prosperous household's finances with full access to the accounts, and full responsibility for their accuracy. I understood money in its practical dimensions, what things cost, what income was reliable, and what was variable, where expenses could be reduced without visible impact, and where reduction would produce problems. How to read a set of accounts and understand what they were telling you about the health of the enterprise they described. Augustine had given me this responsibility early in our years together, partly because he trusted me, and partly because he was not himself particularly interested in the details of domestic financial management, and I had expanded that responsibility over the years until I was in practical terms the financial manager of the household. I had also managed Augustine's business affairs in ways that he had permitted and that his associates had initially resisted and eventually accepted. The commercial property on the main street, the one that generated $2,000 per year in rental income, had been my project in the sense that I had identified the tenants, negotiated the rental terms, managed the maintenance, and handled the disputes that arose over 16 years with the kind of competence that produced results regardless of the social context in which it operated. Men who had been uncomfortable dealing with an enslaved woman on commercial matters had become accustomed to dealing with me because I was good at it, and because the alternative was dealing with Augustine, who was less interested in the details and less pleasant in his manner. This meant that when Philippe filed his first legal challenge, I was not a woman who needed to learn about money and property and legal documents from the beginning. I was a woman who had been He was 60 years old when Augustine died, a man who had practiced law in Baton Rouge for 35 years and who had acquired over those years the particular combination of competence and cynicism that long legal practice in a deeply unjust system tended to produce. He was not an abolitionist. He was not a man who believed that the legal arrangements of Louisiana society were wrong in any fundamental sense. He was a professional who had been asked by a client to prepare a document, had prepared it with professional care, and who found himself, after his client's death, in the position of having to defend that document against a sustained legal assault that he had anticipated, but that was proving more prolonged and more complicated than he had expected. What kept him engaged was not idealism. It was professional pride and something I can only describe as a lawyer's obstinacy, the refusal to accept that a well-constructed document should fail simply because the people arrayed against it had more social power than the person it was designed to protect. Fontenot had constructed the manumission and the bequest carefully and correctly, and the argument that Augustine had been of unsound mind offended him in the way that a craftsman is offended by the suggestion that his craft is defective. I understood this, and I worked with it. I did not appeal to his conscience about the justice of my situation, because I assessed his conscience as unlikely to be moved by that appeal, and because any appearance of supplication would undermine the professional relationship I needed to maintain. I treated him as a professional dealing with a client, which is what we were, and I was a client who was well-informed, well-prepared, and capable of contributing to my own defense in ways that reduced his workload and demonstrated my competence. He was surprised by this. He had expected, I think, a woman in distress who needed reassurance and guidance, and whose primary contribution to her own case would be to show up when required and not say anything that made things worse. What he got was a woman who had read every document in the case, who could identify the specific legal weaknesses in Felipe's arguments, who knew the financial dimensions of the estate in precise detail, and who had views about legal strategy that were, when he examined them, more often correct than not. After the first year, he stopped being surprised and started being interested. By the third year, he was, within the limits of what his professional position and his social world permitted, something that I would describe as genuinely on my side, not as an ideological matter. As a professional one, he wanted to win because he believed we had the better legal case, and because the challenge to the document he had constructed had become a challenge he took personally. This was enough. I did not need his ideology. I needed his competence and his commitment, and by the third year I had both. The first legal challenge, the unsound mind argument, was resolved in my favor in 1849, 2 years after Augustine's death. The resolution was not complete. The court's ruling was narrow, addressing only the specific procedural question of whether the physician's certification was sufficient evidence of competence, and leaving open several of the broader questions that Philippe's lawyers had raised. But it was a ruling in my favor, and it established the foundation for everything that followed. I was in the courtroom when the ruling was delivered. This was unusual. Free women of color in Baton Rouge in 1849 did not typically attend the court proceedings concerning their own cases, because the social environment of such proceedings was hostile enough to make attendance a complicated and potentially counterproductive decision. Fontenot had advised against it. I had told him respectfully that I would be present at every proceeding in my case for as long as the case continued, that my presence was a statement of legitimate interest in the outcome, and that I understood the risks and had decided to accept them. I sat in the section of the courthouse gallery designated for free people of color, and I listened to the proceedings with the same attention I brought to everything. And when the ruling was delivered in my favor, I felt something that I recognized as satisfaction, but that was too complicated to be only that. It was also the specific sensation of a person who has been told their entire life that the institutions of the society around them are not designed for their benefit, discovering that on this one occasion, in this one narrow question, the institution had functioned as it was supposed to function. It was not justice. It was one procedural ruling in a case that would continue for 10 more years. But it was something, and I recorded it in the journal I had been keeping since the first day of the litigation, the journal in which I wrote down every development and every decision and every piece of information that might be relevant, the journal that would become over 12 years the most comprehensive record of the case that existed, and that Fontenot eventually used as a primary resource in the later stages of the litigation. Philippe was furious. His lawyer, a man named Desmoulins, who was more aggressive and less scrupulous than Fontenot, and who had taken the case on a contingency arrangement that gave him a financial stake in the outcome, filed a motion for reconsideration within a week of the ruling. The motion was denied. Philippe filed a second challenge on the procedural grounds that his lawyers had been developing, and the litigation continued. The house in Baton Rouge was the center of everything, not just because it was the most visible piece of the estate, the one whose occupation was most publicly apparent and most socially provocative, but because it was where my children were growing up, where Josephine was learning to manage accounts, and Thomas was learning carpentry, and Marie was becoming whoever she was going to be, and because the house was the thing I would not give up regardless of what happened in the courts. It was a substantial house on a good street, a 2-story building of the Louisiana Creole style with a wide gallery on both floors and a courtyard in the back where Henri, my father, had planted fig trees that were now large and productive and that I associated with every good thing I had ever known about home. Augustine had bought it 15 years before his death, when the household had expanded and the original smaller house had become inadequate. He had furnished it over the years with the accumulated evidence of a prosperous domestic life, and after his death, I had managed it with the same care I had brought to everything else, maintaining it not just as a residence, but as evidence. Evidence of what I was and what I was capable of. Evidence that the woman Felipe's lawyers described in court as a confused and vulnerable person who had been manipulated by an older man into a situation she didn't understand was in fact a woman who managed a substantial property with professional competence and who was raising 3 children in a household that was, by any visible standard, orderly, educated, and self-sufficient. I was deliberate about this visibility. I understood that the social war being conducted alongside the legal one required its own response, that the hostility of Baton Rouge society toward my position was not something I could change through legal victories alone, and that the most effective counter to the narrative Felipe was promoting, confused woman, unsound man, unnatural arrangement, was the visible daily reality of my life, which was neither confused nor unnatural, but simply the life of a woman managing her affairs and raising her children with competence and dignity. I received visitors, not the white social world of Baton Rouge, which was not available to me in any case, but the free black community of the city, which was substantial and which had its own social architecture, its own networks of mutual support and collective interest. I attended the St. Augustine Catholic Church on Sunday mornings with my children, which was where the free black community of Baton Rouge worshipped, and which was where relationships were maintained and information circulated and support organized. I contributed to the community's charitable institutions. I was present and visible and conducted myself in ways that made the narrative of confusion and vulnerability increasingly difficult to maintain against the evidence of my actual existence. This was strategy. It was also simply how I lived. My eldest child, Josephine, was 15 when her father died and 27 when the litigation finally ended. 12 years of her young adulthood shaped by the legal battle for the estate that was her inheritance as much as mine. She was from the beginning of it her father's daughter in the way that mattered most to what we were doing. She had his methodical mind and his comfort with documents and numbers, and by the time she was 18, she was managing the commercial properties accounts herself, reviewing the rental agreements, tracking the income and expenses with a precision that exceeded what I had been able to provide while managing everything else simultaneously. She was also increasingly my strategic advisor, not because I lacked strategic judgment, but because she had a quality I recognized from her father, the ability to separate her emotional investment in an outcome from her analytical assessment of how to achieve it, to think about the litigation with the detachment that its complexity required, even when the stakes were entirely personal. She was the one who identified in the 5th year of the case the specific weakness in the procedural defect argument that Philippe's lawyers had been building. She had been reviewing the legal documents with the same attention she brought to the financial accounts, and she found in the record a filing from 1833, made by Augustin in connection with an unrelated property transaction that demonstrated in passing that the procedural forms Felipe's lawyers were claiming had not been followed had in fact been the standard practice in Louisiana notarial offices for at least 14 years. The filing undermined the procedural argument at its foundation. She brought it to me on a Tuesday evening with the controlled excitement of someone who has found something important and is trying not to overestimate its importance before having it confirmed. I read it and confirmed her assessment and brought it to Fontenot the following morning. Fontenot read it, looked up at me and said, "Where did this come from?" "My daughter found it," I said. He was quiet for a moment. Then he said, "Your daughter should have been a lawyer." I told him she probably would be in whatever form that was available to her. He looked at me with an expression that I had learned over 8 years of working together to recognize as his version of respect, which was not demonstrative, but was genuine. The filing was incorporated into our response to the procedural challenge. It did not end that phase of the litigation immediately. Felipe's lawyers were skilled enough to find ways around it that extended the proceedings for another year. But it shifted the ground significantly, and contributed to the eventual resolution of that challenge in our favor in 1854. The financial management of the estate through 12 years of litigation was the most practically demanding aspect of what I was doing, and it required a precision and a discipline that I maintained with the same care I brought to everything else. The legal fees were substantial. Fontenot's rates were reasonable by Baton Rouge standards. He had adjusted them early in our relationship in a way that I believed reflected his genuine investment in the case rather than purely commercial calculation. But 12 years of sustained litigation produced costs that accumulated into a significant sum. By my accounting, the total legal fees paid to Fontenot over the 12 years of the case came to approximately $4,800, a sum that represented a significant portion of the estate's liquid assets. The commercial property continued to generate income throughout the period, but that income was not stable. 3 of the property's tenants changed during the 12 years, and each transition involved a period of vacancy and the costs of securing new tenants. In the 4th year of the litigation, a fire in the adjacent property caused structural damage to the commercial building that required repairs costing approximately $900, a sum that depleted the bank account significantly and that Philippe's lawyers attempted unsuccessfully to use as evidence that I was mismanaging the estate. I managed the finances the way I managed everything, with precise attention to what was coming in and what was going out, with careful prioritization of the legal fees that were the most critical expenditure, with constant vigilance for opportunities to reduce costs without reducing the quality of the property or the household, and with a strategic reserve that I maintained at all times against the unexpected. By the end of the 12 years, when the litigation was finally resolved, the estate was smaller than it had been when Augustine died. The legal costs and the property repairs and the ordinary expenses of 12 years of household maintenance had reduced the bank account from $12,000 to approximately $6,400. The commercial property remained intact and income-producing. The house remained in my possession and in good repair. I had spent approximately $5,600 to protect an estate worth significantly more than that. The arithmetic was straightforward. The discipline required to maintain that arithmetic through 12 years of sustained pressure was less straightforward, and I am not modest about the fact that maintaining it was one of the harder things I have done in my life. I did not do this alone. I want to be clear about that because the narrative of the solitary woman fighting the system is both compelling and incomplete. I had Fontenot, I had Josephine, and I had the free black community of Baton Rouge, whose support was less visible in the court record, but without which the 12 years would have been unmanageable. The free black community of Baton Rouge in the 1840s and 1850s was a substantial and organized community with its own institutions, its own economy, its own network of mutual aid and collective defense against the hostility of the white society that surrounded it. It included property owners and tradespeople and domestic workers and educators and religious leaders, people who had carved out spaces of relative autonomy within the severely constrained conditions that Louisiana law and Louisiana society imposed on free black people. Many of them knew me. I had been part of the community in an informal way since coming to Baton Rouge with Augustine in 1831, attending St. Augustine's, participating in the community's social and charitable life in the ways that my particular position, neither fully enslaved nor fully free during Augustine's lifetime, occupying the ambiguous social space that such relationships created, permitted. After Augustine's death and my formal freedom, my participation deepened. The support I received was practical and varied. Information about Philippe's activities and intentions passed through the community's networks, with the efficiency that such networks had developed over generations of necessity. Witnesses who were willing to testify to my character and competence in legal proceedings, at personal cost and social risk. Financial assistance in the 2 periods of the 12 years when the litigation costs and the unexpected expenses coincided in ways that strained the estate's reserves, and the sustained social presence of a community that understood what I was fighting for and why it mattered beyond my individual case. Because it did matter beyond my individual case. What I was fighting for was not just the house and the rental income and the money in the citizens' bank. I was fighting for the principle that a legal document executed correctly by a competent adult should be honored regardless of the race of the person it benefited. That principle, if established in my case, had implications that extended well beyond my particular situation to the broader question of whether the legal rights that Louisiana law nominally extended to free people of color had any practical meaning. The community understood this. Several of the men who provided support and information and testimony did so explicitly in terms of what my case meant for the broader community, not just for me personally. They were taking risks on behalf of a principle, and I acknowledged those risks and did not ask anyone to take them lightly. The litigation ended in 1859, 12 years after Augustine's death, with a ruling of the Louisiana Supreme Court that upheld the manumission and the bequest in their essential elements. The ruling was not a complete victory. Louisiana courts in 1859 were not in the business of delivering complete victories to free black women in property disputes with white men. The ruling preserved my freedom and the freedom of my children. It preserved my ownership of the house and the commercial property. It preserved a portion of the bank account, though Philippe's lawyers had succeeded in attaching legal fees to the estate that reduced the amount I retained. What I came out of 12 years of litigation with was less than what Augustine had left me. The bank account contained approximately $5,200 rather than the original $12,000. The commercial property was mine, but encumbered by a legal instrument that Philippe's lawyers had managed to attach to it in the later years of the case, an instrument that I would spend 3 more years working to clear. The house was mine, fully and cleanly, and so was my freedom and the freedom of my children. It was enough. Not everything Augustine had intended, not the complete vindication of the principle that the documents should have represented, but enough. The house was mine. My children were free. I had something to build from. Philippa died in 1862. I learned this through the same networks that had kept me informed throughout the litigation, and I felt at his death something I had not expected to feel after 12 years of being his adversary. Something close to nothing. He had been the antagonist of 12 years of my life, and his death did not change what those years had contained or what they had produced. He was simply gone, and the litigation was over, and Baton Rouge was about to be consumed by a war that would change everything in ways that made the property dispute that had defined my adult life look simultaneously significant and small. The Civil War came to Baton Rouge in 1862 when Union forces captured the city, and Louisiana's arrangements of race and property and freedom began the slow and incomplete dismantling that would occupy the rest of the century. I was 53 years old when the war began. I had been free for 15 years, property owning for 15 years, a known figure in Baton Rouge's free black community for 15 years. What the war produced in me was not the sudden liberation that it produced in people who had been enslaved until that moment, but something more complicated, the recognition that the world whose rules I had been fighting for 15 years was itself in the process of being renegotiated, that the legal and social framework within which my 12-year battle had been conducted was cracking along seams that ran much deeper than any individual property dispute. Josephine was 29 when the war began. Thomas was 26. Marie was 22. All 3 of them free, educated to the degree that Baton Rouge's constrained options for free black education had permitted, formed by 12 years of watching their mother conduct a sustained legal and social campaign against the kind of institutional hostility that most people would have found overwhelming. What they had learned from watching me, I cannot fully assess. I know what I tried to teach them, which was the same thing in different forms across all the years of the litigation, that the law was a tool, and that tools could be used by anyone who understood them well enough. That money was a form of power, and that managing it carefully was a form of self-defense. That community was not a luxury but a necessity, that no individual could sustain what I had sustained without the support of people who understood that the individual's fight was also a collective one. And that patience was not the same as passivity, that the willingness to fight something for 12 years without losing the precision and discipline the fight required was itself a form of strength that had to be developed and maintained. Josephine eventually became the kind of businesswoman in post-war Baton Rouge that a woman of her abilities should have been able to become from the beginning. She managed the commercial property with a competence that built its value significantly over the years after the war, when the disruption of Louisiana's economy created opportunities for people who understood property and money well enough to move quickly. She married a man named Rouge, who was a teacher and later a community organizer, and their children were educated and free and connected to the community that had sustained their grandmother through 12 years of institutional hostility. Thomas became a carpenter, which was his grandfather Henri's trade, and which seemed to me, when he told me, to be the most fitting possible thing. He built houses in Baton Rouge for 40 years, and some of what he built is still standing. Marie became something that I never fully predicted, and that delights me whenever I think about it. She became a lawyer's assistant, working for a white lawyer in New Orleans, who valued her intelligence and her comprehensive understanding of Louisiana property law. She had, after all, lived inside a complex property case from age 9 to age 21, and who paid her for it, which was in 1860, something that had not previously been straightforwardly possible. I lived in the house on the Good Street in Baton Rouge until I died, the house that Augustine had bought and that I had spent 12 years defending. And that was when all the fighting was over, and the war had come and gone, and the legal instruments had been cleared and the encumbrances lifted. Simply my house. The place where the fig trees my father had planted were now old and enormous and productive, and where I could sit on the gallery on summer evenings and watch Baton Rouge continue to be Baton Rouge, imperfect and incomplete, and still unjust in most of the ways it had always been unjust, but different in enough ways that the difference was real and worth something. I died in Baton Rouge in 1874, at age 65, in my house, in my bed, with my children present. They buried me in St. Vincent de Paul Cemetery, which was where the Catholic community of Baton Rouge, black and white, had always buried its dead together in one of the small ironies of Louisiana religious life. My grave marker reads Celestine Renard Freeman, 1809 to 1874. She held on. That is what I did. Through 16 years of an impossible arrangement, and 12 years of legal warfare, and a civil war, and reconstruction, and everything that preceded and followed all of it. I held on to what was mine. Not because holding on was easy, or because the institutions supported it, or because the people arrayed against me were weak. Because I was precise and patient and well-informed and supported by people who understood that what I was fighting for was worth fighting for. And because Augustine had given me enough of a foundation to fight from, and because I had 3 children who were watching me and learning from what they saw, and because some things are worth 12 years. The house was worth 12 years, my children's freedom was worth 12 years. The principle that a legal document executed correctly should be honored, regardless of the race of the person it protected, was worth 12 years. And the knowledge which I carried to my grave and which I hope is carried further, that institutional hostility and social pressure and the accumulated weight of a system designed against you can be survived by a woman who is careful enough and patient enough and well supported enough to outlast them, that knowledge is worth everything it cost to acquire. This is the story of Celestine. Born enslaved in East Baton Rouge Parish, Louisiana in 1809, freed by the act of manumission executed by Augustine Renard in September of 1847 and upheld by the Louisiana Supreme Court in 1859. East Baton Rouge Parish notarial records document the manumission and bequest executed by Augustine Renard in September 1847. The subsequent litigation, Renard versus Renard, is documented in the Louisiana Supreme Court records and constitutes one of the most extensively documented property cases involving a free woman of color in antebellum Louisiana. Celestine's legal representation by Maître Fontenot is documented in the case record. The commercial property at issue remained in the possession of Celestine and her heirs and is documented in post-war Baton Rouge property records. Josephine Rouge, Celestine's eldest daughter, is documented in Reconstruction-era Baton Rouge records as a property manager and community figure. Thomas Freeman is documented in city records as a carpenter operating in Baton Rouge from 1863 onward. Celestine died in Baton Rouge in 1874 and is buried in St. Vincent de Paul Cemetery. Her case has been studied by historians of Louisiana legal history as a significant example of the use of legal institutions by free women of color in antebellum Louisiana to defend property rights against family challenges. The Freeman family papers, donated to the Louisiana State Archives in 1952, include Celestine's journal of the litigation, which remains one of the most detailed first-person accounts of a property defense case from the antebellum period. If Celestine's story moves you, if you believe that holding on is its own form of courage, that the law can be a weapon in the hands of someone patient enough to learn it, that 12 years is not too long to fight for what is yours, subscribe now and join us as we continue uncovering the stories that history tried to bury. Leave a comment telling us where you're watching from. Tell us what stayed with you most about Celestine's story, the document Augustin signed, the 12 years of litigation. Josephine found the filing that changed the case, the fig trees her father had planted, the 4 words on the gravestone. Your engagement keeps these stories alive. Subscribe, comment, share, and prepare for more voices that history tried to silence but could not.